argument of these arguments is misconceived, and in some cases, they are incomprehensible. Let me address them one by one. First, the idea that the requirement of the existence of a dispute is not one which finds a place in human rights litigation flies in the face of the application of that same requirement to several interstate cases concerning human rights and brought under various human rights treaties. The ICJ considered and restated this requirement of the existence of a dispute in the case concerning the application of the International Convention on the Elimination of All Forms of Racial Discrimination between Georgia and the Russian Federation. And in that case, dealing with the Racial Discrimination Convention, the court engaged in a detailed inquiry of whether the two states had been involved in a dispute on that subject matter at the time the case was lodged before it. That's a racial discrimination case. In a case brought under the Convention Against Torture, the ICJ reiterated that jurisdiction hinges upon the existence of a dispute at the time the application was filed. This was a case between Belgium and Senegal regarding the obligation to prosecute or extradite. In fact, in that interstate case, undoubtedly, human rights interstate litigation, it also offers an example of the legal consequence attaching to a lack of a dispute at the time of the submission. The ICJ not only examined whether a dispute existed between the parties regarding the Torture Convention, it also went on to examine whether a dispute extended to breaches of customary international human rights law. The unanimous bench in that case found that there was, at the relevant time, a dispute relating to the Torture Convention, and for that reason found that it had jurisdiction with respect to that dispute. A large majority of judges also held that there was no dispute between those states relating to breaches of obligations under customary international human rights law, and held that the court had no jurisdiction to deal with Belgium's claims in that respect. As the applicant itself has recognized, the ICJ has also applied the requirement on the existence of a dispute in several cases brought under the Genocide Convention. It's done so in 3 recent cases, all of which are referred to in the applicant's own reply brief. The case between South Africa and Israel concerning the application of the Genocide Convention in the Gaza Strip, the case between Ukraine and Russia concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, the case between Gambia and Myanmar concerning the application of the Prevention and Punishment of the Crime of Genocide. All interstate human rights cases, the ICJ applied this requirement that a dispute must exist at the time of submission. Finally, on this point regarding the application to human rights cases, final point here. The DRC is well aware that this requirement of the existence of a dispute also applies in human rights litigation, not merely from all of these other cases, but also from the experience of the DRC itself in prior interstate litigation that it has been involved in relating to human rights. in a case between the same parties as are now before this court, the DRC and Rwanda. The ICJ applied this requirement to a claim that was brought by the DRC in relation to the Convention on the Elimination of Discrimination Against Women, Human Rights Treaty. This is the case concerning armed activities on the territory of the Congo, new application, in which the court found that it lacked jurisdiction, 2006. Mr. Vice President, honorable members of the court, we urge the court to dismiss the submission that this requirement of a dispute does not apply in a case such as this. This requirement follows from the terms of Article 3 of the protocol, which in turn represents the scope of what the parties to the protocol have consented to. They have only consented to the jurisdiction of the court in interstate cases insofar as a dispute that actually exists at the time, is submitted to it. The court is bound to respect that consent and thus to respect the jurisdictional limits set out in the protocol. And moreover, there is no reason why the court should depart from the practice of other international courts and tribunals like the ICJ, whose jurisdictional instruments similarly refer to the submission of disputes. The second reason to reject the applicant's arguments as to the existence of a dispute is that it is simply wrong to say that this requirement leads to formalism. As the applicant itself has noted, the ICJ has stated on many occasions, and I quote, "The court's determination of the existence of a dispute is a matter of substance, not form or procedure." There is no formalistic approach to the determination of whether there is a dispute. What is required is an examination of the real state of affairs between the states concerned. A third reason for rejecting the argument that there is no requirement of a dispute is that the applicant confuses the requirements for submitting a communication to the African Commission on Human and People's Rights, with the jurisdictional constraints on this court. They insist that a state is able to submit a communication directly to the Commission against another state without first bringing the matter to the attention of the state that is complained against. They then say it must also be possible before this court. The DRC bases this suggestion on what it describes, and I quote from their reply, it describes as a combined reading of Articles 47, 48, and 49 of the Charter. However, reliance here on the provisions of the Charter dealing with submissions of communications to the Commission is misguided. This court is well aware of the fact that the provisions of the protocol relating to the procedure by which cases are submitted to the court are not the same as the provisions of the Charter relating to the submissions of communications to the Commission. As you have previously stated, and I quote, in the case between the African Commission on Human and People's Rights and Kenya, as you stated, and I quote, "The court is of the view that admissibility and other procedures relating to a complaint before the Commission are not necessarily relevant in determining admissibility of an application before this court." Now, this was said in relation to admissibility, but the court also spoke about other procedures relating to a complaint. and the same thinking applies also to the rules regarding jurisdiction. Simply put, those rules are not exactly the same for the Commission as for the Court. Otherwise, the protocol and its carefully delineated language would serve no purpose. In any event, the provisions in Articles 47 to 50 that they rely on, though not directed at the Court, they show how the drafters of the Charter did have in mind that before African institutions are engaged by states who are of the view that violations have occurred, that there should be an attempt at friendly settlement of the issue with the allegedly wrongdoing state. Now, although a state may submit a communication to the African Commission without first having communicated the matter to the state, the Commission is then tasked with seeking a friendly settlement, or what the Charter refers to as an amicable solution. So to compare this careful, amicable process with the unilateral filing of a legal dispute before this court is disingenuous. In all matters submitted to the African Commission, there will first have been a process of identifying the dispute, seeking to understand and resolve it in an amicable way before the Commission moves to the merits of the claim. The requirement of the existence of a dispute does no more than provide similar opportunities for the resolution of that dispute prior to the submission to this court. A fourth reason for rejecting the applicant's arguments that there is no requirement of the existence of a dispute at the time the application is filed is that this argument fails to give effect to the actual words of Article 3.1 of the Protocol. That provision specifically refers to the submission of cases and disputes to the court. The applicant suggests that the word case and the word disputes, as used in Article 3, are interchangeable, and that the court should not, indeed they say, does not make any distinction between cases brought by individuals and those brought by states. This argument, as meaning the same thing as the word case in Article 3.1, is inconsistent with a basic rule of treaty interpretation. This is the principle of effectiveness, the basic rule of international law regarding treaty interpretation. According to this principle of effectiveness, it is not open to the interpreter of a treaty to adopt a meaning which would render the text redundant. Words in a treaty must be given effect to. So when Article 3.1 of the Protocol speaks of cases and disputes, the word dispute must be given effect to and cannot simply be interpreted out of the text. The argument of the applicant that case, the word case, and disputes are in this context interchangeable does not stand up to scrutiny because Article 3 uses both. It uses both of these words. It cannot be the case that the drafters meant to speak of the same thing twice. If the two terms are interchangeable, then Article 3.1 is to be interpreted as speaking about the submission of cases and cases, or to be interpreted as speaking of the submission of disputes and disputes. Clearly, the inclusion of the word dispute is intended to add something different in that provision to the word case. For that reason, it cannot be ignored. And we submit that when Article 3.1 speaks of the submission of disputes, that in accordance with the practice of other international tribunals from where this language is borrowed, it specifically covers disputes between states. Mr. Vice President, honorable members of the court, having established that in interstate cases like this one, the court's jurisdiction only extends to the submission of disputes that were in existence at the time of the filing of the application. Let me now turn to the application of that condition in these proceedings. So what does it mean in these proceedings? As was set out by the Permanent Court of International Justice in the famous Mavromatis Palestine concessions case, and has been repeated on many occasions, a dispute between states, and I quote, is a disagreement on a point of law or fact, a conflict of legal views or interests, end quote. We have set out in our written pleadings the key principles that are to be used to identify a relevant dispute between the parties. First, for a dispute to exist, and again I quote from the Mavromatis case, quote, it must be shown that the claim of one party is positively opposed by the other, end quote. It must be shown that the claim of one party is positively opposed by the other, end quote. This reference to the claim of one party being opposed by the other relates specifically to the claims that are later brought before the court. It is not sufficient to show that the parties have disagreements or differences in relation to other matters. For there to have been a relevant dispute, the ICJ has stated, and I quote, the evidence must show that the parties hold clearly opposing views with respect to the issue brought before the court. With respect to the issue brought before the court. Second, again, as the ICJ has held, a dispute exists, I quote, a dispute exists when it is demonstrated on the basis of the evidence that the respondent state was aware or could not have been unaware that its views were positively opposed by the applicant. Okay, so the respondent state must have been aware or could not have been unaware that its views were positively opposed by the applicant. This means that for there to be a dispute, the applicant must have set out its claim clearly. In other words, the applicant must have made claims which allow the respondent to understand that the applicant was of the view that the respondent is in violation of legal rights which form the basis of the action, the legal action that is now before the court. Third, while evidence of a dispute can be gleaned from statements that are made by state officials, the court must give particular attention to the content of those particular statements. In particular, a statement will only be said to have given rise to a dispute, or will only be evidence of a dispute, if it refers to the subject matter of a claim, and again I quote from the ICJ, if it refers to the subject matter of a claim, and I quote, with sufficient clarity to enable the state against which that claim is made to identify that there is or may be a dispute with regard to the subject matter. So the statement must refer to the subject matter of the claim with sufficient clarity to enable the state against which the claim is made to identify that there is or may be a dispute with regard to that subject matter. The statement has to articulate an alleged breach by the respondent of the particular obligation or right that is put in issue between the parties in the judicial proceedings. Fourth, the respondent must have had the opportunity to address the particular claim that is made by the applicant. There will only be a dispute where either the claim of a violation of legal right is positively opposed, in other words, it's rejected by the respondent, or the respondent state fails to reply to the applicant's claim of legal violation. Now, judged against all of these principles, it is manifest that there was no dispute between the parties to this case concerning the claims that properly form the subject matter brought before this court. So there was no dispute between these parties concerning the claims that are now brought before this court. The factual record, even as presented by the applicants, reveal that there was no relevant dispute at the time the DRC filed its application. When we say that there was no relevant dispute, what we mean is that at the time when the application was lodged, there was no dispute between the DRC and Rwanda regarding the human rights matters, the human rights claims that fall within the present application. Now, the applicant has tried to overwhelm the court by submitting a multitude of statements and documents which are wholly irrelevant to the issues that properly form the subject of a human rights claim before the court. It has submitted all manner of allegations of supposed wrongdoing by the respondent in order to persuade the court that there was a dispute at the time it filed the application. But what is required is not a suggestion that the parties might have had any type of difference. It has to be shown that the issues that properly form the subject matter of this claim, this case, those issues were in dispute. It has to be shown that there was a disagreement regarding the alleged human rights violations that this court is able to deal with. Now, the applicant has submitted a number of statements in which it accused the respondent of aggression and of unlawfully using force within its territory. It then suggests that those statements in this regard and their opposition by Rwanda constituted a dispute before the application was filed. But this approach and the documents submitted reveal very clearly that there was no dispute between the parties regarding the subject matter within the jurisdiction of the court, violations or alleged violations of human rights. As the court will have noted, the DRC did not, in those documents that it submitted, those documents predating the filing of the application, in those documents it did not allege violations of human rights. They alleged aggression. They alleged unlawful use of force. What those documents show is that the DRC's application is really an attempt to bring matters concerning peace and security before this court. As we will show tomorrow in our presentation on admissibility, this attempt to mischaracterize matters relating to use of force and maintenance of peace and security as within the competence of the court, it permeates the case throughout. And it makes this case inadmissible for several reasons that we will discuss tomorrow. Moreover, as I will show very shortly, claims under the UN Charter, the Charter of the United Nations, under the African Union Constitutive Act, fall outside the jurisdiction of this court, as they are not human rights instruments as set out in Article 3 of the protocol which defines your jurisdiction. But for now, let us look at the statements that the DRC cites in its reply brief as demonstrating the existence of a dispute between the parties. First, there is the statement of the President of the DRC, made in the United Nations General Assembly on the 20th of September 2022. They rely on it in their reply brief. In that statement, he accused Rwanda of making direct incursions into the territory of the DRC and of engaging in occupation. But he did not make any claims of the violations of human rights, the type of violations that this court can actually deal with. True, the President of the DRC referred to the United Nations Charter, he referred to the African Union Constitutive Act, but as I will show shortly, these are not human rights instruments within the meaning of Article 3. There is therefore nothing in that statement that would enable the respondent to know that there was a human rights dispute regarding matters that are now brought before this court. Rather, what was being alleged there was an act of aggression, an allegation that, beside being thoroughly contested, does not fall within the jurisdiction of this honorable court. The DRC further contends that on the 19th of November 2022, that at the 18th summit of the Organisation Internationale de la Francophonie, that its prime minister refused to take a family photo in protest against human rights violations by Rwanda. First, there is no evidence that is given of any particular reasons that were offered at the time by the Prime Minister for refusing to take the photo. Also, it is hard to see how this act of declining to take a photo could possibly fit within the ICJ's jurisprudence that a statement only gives rise to a dispute when it is sufficiently clear in referring to a dispute about the specific subject matter brought to the court. Likewise, in the statement of the DRC's permanent representative to the United Nations, made before the UN Security Council on the 29th of March 2003, there was no mention made of human rights or of any treaties that this court has jurisdiction to apply. Again, the chief leitmotif of these statements is the allegation that Rwanda has committed aggression. But that is not a human rights claim that is justiciable before this court. That is another matter, and that is not the dispute that is submitted to this court. Mr. Vice President, you may be relieved to know, honorable members of the court, we don't have time to go through all the statements that the DRC refers to in its reply. But when you look at them individually and you take them as a whole, a few things emerge. They do not refer to the human rights treaties that are properly within the jurisdiction of the court. They do not even refer to human rights. The DRC has now, in its reply, adopted commentary that liberally asserts violations of human rights. But the statements themselves do not say so. The statements accuse Rwanda of using force, supporting the use of force, undermining the DRC's territorial integrity, but that is not a human rights dispute. Those are not human rights violations. On occasion, these statements make allegations about specific incidents that they allege has led to loss of life. But again, there is nothing that indicates with clarity that these claims are distinct from the usual allegations of violations of territorial integrity or sovereignty, or even an indication that those allegations of loss of life arise from human rights violations. So to conclude on this first aspect of the jurisdictional objection dealing with material jurisdiction, Rwanda submits that it is a condition of the court's jurisdiction in interstate cases that a dispute about human rights must have existed at the time when the application was submitted to the court. And in our submission, it is very clear that at the time this application was filed, even if there were some differences between the DRC and Rwanda on other matters, it cannot be shown that there was a dispute relating to the human rights treaties or human rights violations that form the basis of the court's jurisdiction. Mr. Vice President, honorable members of the court, let me now turn to the second argument that we have regarding lack of material jurisdiction. That's the argument that aspects of this case fall outside of the material jurisdiction of the court because the applicant relies in part on documents that are not human rights instruments ratified by the respondent. With your indulgence, let me again quote from Article 3, Paragraph 1 of the protocol. I quote again, "The jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation of the Charter, this protocol, and any other human rights instrument ratified by the states concerned, and any other human rights instrument, any other relevant human rights instrument ratified by the states concerned." This provision is crystal clear. The court has jurisdiction to entertain claims brought not only under the African Charter and Protocol, but also under other instruments, as long as two conditions are met. One, those instruments must be relevant human rights instruments. Two, those instruments must be ratified by the state concerned. Which Rwanda accepts falls within those instruments. The DRC also includes violations of the United Nations Charter, the Constitutive Act of the African Union, the Pact on Security, Stability, Development in the Great Lakes region, the Peace, Security, and Cooperation Framework Agreement for the Democratic Republic of Congo and the region. Now, I note that in the application that was originally filed by the DRC, those instruments were referred to, but the DRC did not make it clear that it was alleging a violation of those instruments. However, in its reply brief, the DRC clarifies that it was indeed alleging a violation of these instruments. Rwanda submits that the court does not have jurisdiction to deal with alleged violations of the 4 instruments I have just mentioned. This is because, 1, they're not human rights instruments. In the case of the Great Lakes Pact, and in the case of the Peace, Security, and Cooperation Framework, they are not instruments ratified by Rwanda or indeed by any other state because they are not treaties. To make a definitive finding that these instruments, these 4 instruments, fall under the jurisdiction of the court. It also alleged that some of this conduct also violates the African Charter or other human rights treaties. As a general matter, the jurisdiction of the court is defined by the consent that states have given. And the court should, and indeed must always, be careful to ensure that it is sticking to the competence it has been given. States have only given the court a mandate to deal with violations of human rights instruments that are binding because they have been ratified. No more than that. In this specific matter, the DRC tries to muddy the waters by mixing matters relating to peace and security with human rights claims. This is a human rights court that is tasked with dealing with violations of human rights. The applicant does not hide its intention to draw this court into deciding on matters relating to the use of force. It says very clearly in its reply, and I quote, "There is an inextricable link between human rights and the use of force, peace, and security. The use of force by one state, Rwanda, against another state, the DRC, as in the present case between these 2 states, has a negative impact on human rights in that it generally leads to the violations of these rights." End quote. In other words, the applicant is suggesting that whenever there are this court will automatically have jurisdiction to deal with such a case under the guise that this is a matter concerning human rights. Nothing will bring this court into greater disrepute than this sort of argument. And such an attempt to broaden the jurisdiction of the court beyond the mandate that it has been given must be rejected. The other point that is of relevance here is that by insisting that the court has jurisdiction to deal with claims under the UN Charter and the AU Constitutive Act and other peace and security instruments, the DRC seeks to claim that the matters it now brings to the court are the matters that were already in dispute between the parties at the time when it filed its claims. As I showed you, the DRC made reference to a number of statements in which it claimed that Rwanda was using force on its territory, allegedly in violation of the UN Charter and the AU Constitutive Act. In arguing that these are issues within the jurisdiction of the court, the applicant is trying to show that there was some continuity between the issues that were raised in those statements and matters that are now within the jurisdiction of the court. If the court were to confirm that alleged violations of the UN Charter, the AU Constitutive Act, and other instruments relating to peace and security do not fall within the jurisdiction of this court, this would also confirm that there was, in fact, no dispute between the parties relating to human rights prior to the filing of the application. Let me now turn to the two conditions that I referred to in relation to these instruments. The test for ascertaining whether an instrument is a human rights instrument is fairly simple, and it has not been particularly contentious. This court has been very clear as to whether it considers an instrument to be a human rights instrument. You stated in one of your previous cases, Action pour la protection des droits de l'homme against Côte d'Ivoire, you stated, and I quote, "In determining whether a convention is a human rights instrument, it is necessary to refer, in particular, to the purposes of such convention. Such purposes are reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by mandatory obligations on states parties for the consequent enjoyment of human rights, of the said rights, sorry. I repeat, such purposes are reflected either by an express enunciation of the subjective rights of individuals or groups of individuals, or by mandatory obligations on states parties for the consequent enjoyment of the said rights." The key requirements here are very clear. There has to be an express enunciation of the human rights in question in that instrument, or obligations have to be imposed on states with regard to the said rights, the particular rights that are in issue. The DRC makes an issue of the translation of this passage that I have just quoted. And they argue that it has a slightly different meaning in the French translation. The DRC argues that the French version of this judgment shows that the instrument does not need to set out binding obligations. However, in making this argument, it has left out relevant wording that undermines its argument. The relevant paragraph from that judgment does not simply state that the obligations in question are, and permit my with your indulgence, I'll use my very poor French. So the judgment does not really state that the obligations in questions are obligations impliquant la jouissance, as stated by the applicant. Rather, this judgment referred to la prescription à l'égard d'État. So the stipulation of obligations regarding states that involve the consequent enjoyment of human rights. In short, the instrument must provide for binding obligations with regard to human rights. Now, we do not argue that a treaty is only a human rights instrument if it exclusively deals with human rights. However, we do say that when the court speaks of an express enunciation of subjective rights of the individual, it does require that specific rights are set out in the instrument. Although the UN Charter and the AU Constitutive Act refer to the promotion and the protection of human rights when listing the aims of those organizations, neither instrument actually sets out specific rights. They do not include an express enunciation of such rights, nor do they provide obligations regarding the enjoyment of any particular rights. The applicant suggests in its reply that the court has held that the Constitutive Act of the AU and the UN Charter are human rights instruments because the court has referred to such instruments in its judgment. With regard to the AU Constitutive Act, the applicant refers to the judgment of this court in the Mohammed Abubakari versus United Republic of Tanzania case, where it is true that the court did in fact make reference to the Constitutive Act of the AU. However, that case in no way supports the applicant's position. The issue in that case was whether the application was admissible. And what the court was considering was whether the provisions in what is now Article 50, Paragraph 2b of the rules of the court on admissibility had been complied with. One of those conditions in Article 50, 2b, in fact, a condition that Rwanda has invoked in this very case, and which my colleague will elaborate on tomorrow, is that the application must be compatible with the Constitutive Act of the AU. In other words, the rules require that the application must not violate the Constitutive Act. Let us be clear what this requirement means. It is the application that must not violate the Constitutive Act. It is not that the court is to examine whether the conduct of the respondent is a human rights violation of the Constitutive Act. In fact, in the Mohammed Abubakari case, it had been argued that the application was inadmissible because the applicant had not alleged breaches of human rights in violation of the Constitutive Act. It was in response to that argument that the court explained that the provisions of the rules, which say that the application must not be incompatible with the Constitutive Act, does not render, or in that particular case, did not render an application inadmissible because it did not allege that the conduct of the respondent violates the Act. It was in that context that this court stated, and this is what's important, and I quote, it's in that context that this court stated, I quote, "The violations alleged in the application are susceptible to be examined by reference to the Constitutive Act and or the Charter and are not manifestly outside the scope of application of those instruments." In other words, examinations of the violations of the human rights instruments must not be debarred by some incompatibility with the Constitutive Act. That was the point. So there's nothing in that case that suggests that the Constitutive Act is a human rights instrument. Let me now turn to the UN Charter and whether it is correct to say, as the DRC does, that this is a human rights instrument within the meaning of Article 3 of the Protocol. It's true that members of the UN in Articles 55 and 56 of the Charter pledge to take action in cooperation with the United Nations Organization for the achievement of respecting human rights and fundamental freedoms. However, the Charter does not anywhere specify any particular human rights, meaning that the express enunciation of rights that this court has said is the standard for a human rights instrument is absent. Furthermore, it is hard to say that Article 55 and 56 specify clear obligations with respect to human rights, such as this court would expect from a human rights instrument. In exactly the same provision, members of the UN also pledge to take action to achieve full employment, higher standards of living, solutions of international economic and social problems. But we do not then say that there is a violation of the UN Charter when these lofty goals are not achieved. The applicant, in its reply brief, suggests that this court has found that the UN Charter is a human rights instrument. They refer to the case of Frank David Omari and Tanzania. However, this is incorrect, as the applicant, again, misunderstands the court's reference to the UN Charter in that judgment. In that case, what the court actually said was, and I quote, "In fact, Article 60 of the African Charter authorizes the court to draw inspiration from international law relating to human and people's rights, in particular from various African human rights instruments, the United Nations Charter, the Constitutive Act of the the Charter of the Organization of African Unity, and the Universal Declaration of Human Rights." To understand what the court was saying in that case, it is important to note that Article 60 of the African Charter is actually directed at the Commission. It is the Commission, which has a different mandate, that is specifically directed to draw inspiration from those materials. Now, this is important because though the court says that it may draw inspiration from those materials, it is clear that the court can only draw inspiration from those materials once it is established that it has jurisdiction. And the court's jurisdiction is only established after it is determined that the application is based on a human right instrument ratified by the state concerned. In fact, it's very clear that in that case, the Omari case, the court was not using those materials to define what is a human rights instrument. Very clear, because the court in that case lists the Universal Declaration of Human Rights, and then the court clearly says that the Universal Declaration of Human Rights is not one of the human rights instruments that fall within Article 3 of the Protocol. So all the court was saying is that once jurisdiction is established, it can draw inspiration from international human rights law, for example, to interpret the instruments that are in fact within its jurisdiction. In summary, there is nothing in the court's case law that deviates from the starting point that in determining whether a particular treaty is a human rights instrument within the jurisdiction of the court, that treaty has to contain an express enunciation of the human rights in question. The Constitutive Act of the AU, the United Nations Charter, do not do so, and thus they are not human rights instruments within the meaning of Article 3. Mr. Vice President, honorable members of the court, let me now briefly turn to my final point. And this is the second reason why some of the instruments relied on by the applicant fall outside the material jurisdiction of the court. This is the requirement that not only must the instruments be a human rights instrument, it must be one that is ratified by the states concerned. In other words, the court only has jurisdiction to consider violations of treaties that the respondent state has become party to. Only treaties are ratified by states. The drafters of the protocol chose their words carefully. The purpose of this requirement is only to include within the material jurisdiction of the court allegations of violations of instruments that are explicitly ratified by the respondent. The DRC seeks to found the jurisdiction of this court, in part, on the Pact on Security, Stability, and Development in the Great Lakes region, and on the Peace, Security, and Cooperation Framework Agreement for the Democratic Republic of Congo and the region. However, these are not treaties ratified by states and certainly not by Rwanda. Thus, even if they were to be regarded as human rights instruments, a characterization that Rwanda disputes for the reasons I have set out, they fall outside the material scope of the court's jurisdiction. Despite this very clear text, and indeed it could not be clearer, we were very surprised to read in the applicant's reply brief the suggestion that this court's case law says the opposite of what the protocol provides for. The DRC says that it is not essential for every human rights instrument to have been ratified in order to establish the court's substantive jurisdiction. I'm sure that this will come as a surprise to the court too. To justify its claims that the court has jurisdiction over alleged violations of instruments not ratified by the states concerned, the applicant refers to cases where it says the court has applied the Universal Declaration of Human Rights. The Universal Declaration of Human Rights, it's not a treaty. It has been referred to by the court, but the court has been clear, crystal clear, that the Universal Declaration is not a human rights instrument that falls within Article 3. Reference was made by the applicant to the Frank David Omari case that I've just referred to, Frank David Omari and Tanzania. There, this court ruled in paragraph 74 of your judgment that reference to the Universal Declaration is permissible, and I quote, as long as the alleged violation is also provided for by a treaty ratified by the state concerned. This court, end quote, end quote. This court then went on to state in the very next sentence, as if for the avoidance of any doubt, this court then stated, quote, the court has the power to exercise its jurisdiction over alleged violations in relation to the relevant human rights protection instruments ratified by the respondent, end quote. So not only is the text of Article 3 of the protocol very clear, the case law of this court is also clear. For the court to have jurisdiction, the instrument must have been ratified by the respondent. For this reason, we submit that allegations of violations of instruments that are not treaties fall outside the material jurisdiction of the court. Mr. Vice President, honorable members of the court, with your indulgence, let me bring my presentation to an end by repeating Rwanda's submissions that the application must be dismissed because, one, the case falls outside the territorial jurisdiction of the court, and two, because the case does not fall within the material jurisdiction of this court. Honorable members of the court, this concludes Rwanda's presentation on jurisdiction this morning. I'm very grateful to you for your kind attention.
Merci pour les exceptions soulevées. À présent, nous allons observer une pause d'1 heure de temps. Au retour, il y aura l'État requérant qui va plaider en réplique sur les exceptions de compétences.
To present its objections regarding jurisdiction. Thank you very much.
Between matters and conflicts which are from the same level of syntax, coordinate and unify two terms whose semantic meaning cannot be distinguished. It would have been the same if the article used a comma before the word and if it had been written in this manner, I quote, "The court has jurisdiction to hear all cases, comma, and all matters or conflicts, the meaning would not have been very different. If the court wanted to make a semantic difference, it would have put a comma before the word and, but that's not the case here. And it would have been different also if we found repetition of the conjunction and to show a difference between the terms which have been enumerated. There, in a similar case, therefore, we could say that there's a difference in meaning between the two terms, notably, if the provision was stated as follows, and I quote once again, the court has jurisdiction to hear and all the cases, comma, and all the conflicts, end of quote. The and in this case would have had the status of an additional conjunction which would have given specific meaning for each term enumerated. But unfortunately, this is not the case. In any case, the shortness of Rwandan reason emerges when we come to the other uses of the same conjunction and, which is used after the same provision under Article 3.1. So, we become aware, for instance, the second use of and, which exists between the terms interpretation and application, plays the cumulative role of the fact that these two terms fall under the purview of a reasoning where they are linked, and we can even say they are integrated. So the mission of this court does not only consist in interpreting, but also in applying. To apply an instrument, you should first of all have the meaning within the purview of a human rights case. Before this court, the application which they do of the charter, the protocol, and other relevant human rights instruments is as a result of interpretation. The third level of meaning of conjunction, of the conjunction and, in the provision of Article 3.1 is preceded by a comma. And here, the conjunction and comes after the enumeration of the charter and the protocol. And here, there's an additional conjunction which is different from the first enumeration of the expression different and case, or matter and case. The third conjunction and plays the role of biconditionality because it is required to express a condition which is necessary and sufficient. In other terms, it does not suffice for any other relevant human rights instrument to exist. There's also the condition of being ratified by the states concerned for this court to have jurisdiction to interpret and apply it. This means that the court will have jurisdiction if and only if all other relevant human rights instruments have been ratified by the states concerned. In all, following every logic, the DRC considers that every good interpretation cannot admit that the term différent and affair before this court should be used indistinctively to refer to the word conflict, an ordinary conflict between two parties before the court, where one is an individual or a state alleges the violation of human rights claimed to have been committed by the other or a state, where the first holds the second as being responsible. The jurisprudence of this court is indeed a reference which we cannot set aside. And it is a testimony of the fact that the court alternatively uses the term différent or the term affair for individual cases, just as it does for interstate cases. Significantly, therefore, it should be noted that it is not by chance that this court, in its order of 7th March 2024, rendered, in this case, referred only to the word affair, and Rwanda cannot claim that the judges of this court did not know that this conflict was between two states. So if the term différent had a particular meaning in the system of the court in interstate contentious matters, why did the court prevent itself from using that word? And even more, if the court preferred to use the word affair with regard to the instant case in its ruling, whereas it had the two concepts before it, by virtue of which, so why should Rwanda substitute the word affair and the word différent, whereas they are all referring to cases? This becomes even more legitimate when we consider the fact that even in the hypothesis of individual cases, the court follows the same logic. The proof is that the matter Subi, Gore, and others versus the Republic of Cote d'Ivoire is indeed an excellent example. In this matter, the court explicitly stated, and I quote, that the protocol does not make any distinction between cases or matters that are tabled before the court as long as this conflict concerns the application and interpretation of all the instruments under Article 3 of the protocol, end of quote. Honorable judges, it is important to note that the court even goes further in the explanation of the meaning of words. In fact, it uses, in the place of the coordinating the conjunction, and it uses another coordinating conjunction where in its cases. And this is not by accident. So they seem to be an equivalent in use, and they could be alternatives. And this means that the concepts affair and différent are identical. They refer to cases or matters or conflicts, and therefore they can be used indistinctively in an individual case, such as in interstate cases. To that end, this court will simply dismiss the argument of Rwanda in challenging its material jurisdiction. Mr. Vice President, honorable judges, fourthly, I want to say that in bid as it may, the evidence of differences between Rwanda and the DRC are many. Rwanda would like to pretend that even if we consider the hypothesis that the court should consider that the existence of a difference or a conflict could affect its jurisprudence, the DRC of the position that there are lots of differences between Rwanda and DRC. Let me use this opportunity to say that the existence of a conflict between Rwanda and DRC are many. And Rwanda comes up with the illusion on this aspect. The DRC has presented through its submissions several points which establish unequivocally conflicts which exist between the two parties at the time when this court was seized of the application. And it was contained in the submissions, and the submissions which have been given before you have demonstrated the continuous nature of these flagrant violations of human rights, which Rwanda is trying to challenge, at times implicitly, at times explicitly. The last episode has just taken place last week in Geneva in the Human Rights Council of the United Nations, which under point 1.3 of its resolution condemns very strongly all the human rights violations, strongly condemns the military and logistics support of the Rwandan Defense Forces to the M23 Defense Forces, calls on Rwandan forces to bring to an end their violations of human rights, end of quotation. Honorable judges, when a resolution like this of the Human Rights Council uses terms such as condemns very strongly, calls on, it is not optional. And in any case, from the point of view of the DRC and Rwanda, on the violation of human rights, where the first holds the second, has been responsible and expressed in several ways and on several occasions. They are manifestly opposed. By way of illustration, we would like to state the following facts. One, Rwanda is playing the role of the ostrich. The DRC is blaming Rwanda of attacking its territory by using M3, which carries out several violations of human rights. That's a strategy which it has carried out for several years by fabricating these two rebellious forces which it controls, CNDP, M23, etc. For its part, Rwanda denies categorically by claiming that the conflict between the M23 and the government of Congo is a domestic problem, and that Rwanda should not be taken as a scapegoat or be assimilated to M23. However, while Kigali blames Kinshasa of habitating a group which was in charge of the case in Rwanda, on the 14th of 2022, a UN representative wrote to the Security Council where a letter of the Minister of Foreign Affairs of DRC was annexed, and it stated clearly that there were accusations of human rights violations committed on the 10th of June 2022 at 2:15 by Rwandan forces in Giruma and Kabaya, situated in the Kisigari region in Buisha, in Rutu region. On that day, scores of bombs were fired through long-range cannons from Rwanda, and it led to human and material destruction, the destruction of a school, Institut Saint-Gilbert, the death of 2 children, Shaka Mapenzi and Jeremy Evumbiza, and they were both 7 and 6 years old. The Congolese minister would like to recall that 2 soldiers of the Rwandan Defense Forces were captured on the 28th of May 2022 by the Congolese Defense Forces with the support of the local population. On that occasion, the Congolese government called on the council to deal with this letter, calling on it to circulate it as an official document of the Security Council. As in reaction, Rwanda dismissed categorically all the accusations made by the DRC on the bombings on its territory. And with regard to its soldiers who were captured, the government of Kigali stated that the 2 soldiers of the Rwandan Defense Forces were kidnapped on the 28th of May 2022 by a joint force, FADC and FDL, whereas these soldiers were patrolling the borders between the DRC and Rwanda. Thirdly, and just by indication, during the meeting of the Security Council on the 9th of December 2022, the Congolese Minister of Foreign Affairs clearly underscored the responsibility of Rwanda in the massacre of Congolese population on the 28th and 29th of November 2022 at Kishishe and Bambo in Hutu territory. Mr. Vice President, honorable judges, the tragedy of that day, which should be called the Kishishe genocide, was indeed particularly cruel because it was planned and it led to the massacre, systematic massacre of the population. And if we look at this situation, even people who were sick in hospital were killed. People who were hiding in schools and in churches were killed. Rwanda expressed, in accordance with its traditional rhetoric, a categorical denial of these accusations. In a communique published on the 22nd of December 2022, they protested in these words, I quote, "Trying to deal with complex situations by repeating and applying false accusations of the government of the DRC cannot lead to a sustainable solution. Notably, the mediatization of the massacres of Kesi, which is fabricated by the government of the DRC, which it attributed to M23, and without any investigations, this spread far and wide. Whereas there are indications that, on the contrary, there was confrontation between the M23 and illegal armed groups related to FDC. End of quote. Mr. Vice President, honorable judges, it emerges from all what follows and the affirmations contained in the submission of the DRC that Rwanda was aware of these allegations of the applicant and reacted by protesting against some of the accusations. At times, Rwanda relies on eloquent silence, and when it is blamed for carrying out genocide on Congolese territory. For all these reasons, the applicant praised this court to dismiss the claims of the respondent state and to declare that it has material jurisdiction. While I would like to thank you all for your attention, I'd like to pray you, Mr. Vice President, and the court to give the floor to Barrister Marcel Muchunga to talk about territorial jurisdiction. I would like to thank you.
Vice President, honorable judges, it is a real honor for my modest person to take the floor within the framework of this procedure. I am speaking in my turn following my esteemed colleague, Mr. Jean-Paul Seguioli, to complement the pleadings and submission of the DRC on this aspect of jurisdiction, especially the territorial jurisdiction of the African Court of Human and People's Rights. We have to underline from start that the point is not to address the issue of extraterritorial jurisdiction, of national jurisdiction of the respondent state. As a reminder, the territorial jurisdiction before such a court is understood according to the venue the dispute occurs. In this situation, the question to which we have to answer consists in clarifying whether the court has the capacity to decide on the violation of human rights alleged by the applicant, by the respondent state, while they have not been committed on the Rwandan territory, but rather on the Congolese territory. The answer to such an interrogation that is very important given this situation is facing two contradictory theses or assumptions. The first assumption is supported by the applicant state. The point is to answer by yes, starting on the fact that the violation of human rights were committed on the territory of a state party to the protocol establishing this court. On the other hand, the second assumption defended by Rwanda suggests that the court is not competent insofar as that the alleged violations are not committed on its territory. As a reminder, the scope of this court is determined or defined in Article 3 of its protocol. The latter reads as follows: the court has jurisdiction to consider all the matters and all the dispute referred to it regarding the interpretation and the application of the Charter, the Protocol, and all other relevant instruments relating to human rights and ratified by the states concerned. In case of contestation to know whether there is jurisdiction or no, the court decides. The DRC confirms that no reasonable interpretation of this provision can confine the competence of the court to the only case of human right violation committed on the respondent state territory. And this is based on 4 reasons supported by the DRC. First, the literal reading of this article or provision. Second, the relevant jurisprudence of this court on this very issue. And 3, the jurisprudence of the Commission of Human and People's Rights on this issue. And 4th, the principle of the usefulness of the interpretation of the preamble. Honorable Vice President, honorable judges, the very broad formulation of Article 3 suggests an extension of competence of jurisdiction of the court beyond the territory of the respondent state where violation of human rights occur. From the reading of Article 3 of the protocol, it appears that the author did not deem necessary to limit the territorial meaning to the territory. On the opposite, it tried to divert from the authors of the ICG and the International Pact on Civil and Political Rights that were animated by the manifest will to limit the territorial competence of the European Court of Human Rights and the Committee of Human Rights to the territory of the respondent state. This stems from Article 1 of the Convention, the Safeguards Convention of Human Rights and Fundamental Freedom, according to which all the contracting parties recognize to all persons under this regulation recognize the rights defined under this convention. Similarly, it is the same for Article 2, Para 1 of the International Covenant on Civil and Political Rights that provides that the state parties to this covenant commits and undertakes to respect and guarantee to all individuals on their territory and relating to their jurisdiction the rights recognized under this covenant. What we can say here is that the fact that the protocol have not limited the territorial competence to the jurisdiction like the European Convention, or to the territory and the jurisdiction like the International Covenant on Civil and Political Rights of the state party, is not done by chance. It shows the willingness to assume a broad competence of the court that has established it. This position defended by the DRC and supported by the doctrine in the field shows the point of view defended by an author regarding the African system on human rights, who is very well known, Judge Kibambai. And this is what he says, and I quote: "The violation incriminated has it to be committed in the territory of one of state party so that the commission becomes competent? It doesn't exist in the charter an equivalent of Article 1 of the European Convention, according to which these states guarantee the right of the persons under their jurisdiction. But since there is no limitation regarding the obligation of the state parties to the charter to protect the rights that it recognizes, we have to deduct that the commission is competent even if the violation imputable to a state party occurs vis-à-vis a person protected beyond and outside the national territory," end of quote. It goes without saying that what is done in the commission should be applied to the court, given the complementarity between the two institutions. Similarly, Honorable Judge Blaise Chikaya notes in his individual opinion, which is appended to the ruling of the court Morna against the Republic of Ghana and others, the following. We have to recall the terms of Article 3 that do not exclude any matter from the jurisdiction of the court as long as it is seized regarding the interpretation and the implementation of this charter or any instrument ratified by the state which is pending in terms of human rights. And he says, it is the court that should decide on it. So it is wrongly that Rwanda affirms in its preliminary submission that given the absence of a similar terminology, similar to the one found in the International Covenant on Civil and Political Rights or the European Convention on Human Rights, the court is right to limit its territorial jurisdiction to the facts committed in the territory of the responding state. This affirmation does not come from a wrong comprehension of Article 3 of the protocol, but also and above all from the jurisprudence of the court, which is in favor of a territorial jurisdiction which is wider. The second argument of the DRC, as we said it, is that the lessons drawn from the jurisdiction of the court itself lead to the competence beyond the national territory of the responding state. This court has always retained the status of state party to the protocol and to the charter as a principle to determine its jurisdiction. So the jurisdiction is either explicit, it is the case when the assumption is to consider this issue in a given angle, or implicit when cases where the question was not similar to this case. The territorial jurisdiction of this court is confirmed in a recent ruling that deserves to be evoked within the framework of this matter. So, the court has explicitly affirmed its jurisdiction through two judgments, at least, where the circumstances were calling for a very accurate response on the territorial competence on facts done and beyond the respondent state. In the case of Yakuba Traore versus Mali, the court deemed that its territorial jurisdiction, it underlines that the alleged violation occurred on a territory of a member state of the African Union. It has, therefore, territorial jurisdiction. This position goes within the framework of its similar motivation as appearing in the judgment of March 2016 in the matter Mogande and 9 others, where the court has deemed that regarding its competence, it deems that given the fact that the alleged violation occurred on a territory of the African Union state, where the state parties are members, so it has jurisdiction to examine this matter. So Rwanda did not mention this jurisprudence, but maybe with some more judgment, we could see clearly that in these two examples, the court has admitted and widened territorial jurisdiction. Indeed, the relevant criteria to declare itself competent needs the fact that the violation were happening in a territory of the African Union, that is to say a state party of the Charter and the protocol establishing this court. It is not by the interpretation of Article 3 of the protocol is in conformity both to the general nature of its formulation and the will of its author. The other judgments of the court on the territorial jurisdiction cannot be interpreted only on the light of these two judgments. In order to establish a territorial jurisdiction, the court base itself on the Court on Human Rights. That is to say, one state party, the respondent state, one state party who is the applicant. So the respondent state is party to the charter, and the state party, or the respondent party. So when we use the term namely, it means that, in other words, among other things, in particular, including, so when the court talks about state party, that is to say respondent state, it means the state party, namely, for example, or among others, the respondent state. Regarding the word namely, it means in this case, in this very case, when the court says the state party, that is to say the respondent state, it means state party. Within this case, the respondent state. So in all the jurisprudence, the court does not contradict itself, and it doesn't question the state party to determine its territorial borders. The court notes the following, and I quote, contrary to the text applicable to the European Court of Human Rights and to the American Court of Human Rights, the Charter do not precise any resort. The protocol do not define the competence of the court, but the court has always considered and examined its territorial competence. The jurisprudence in the field of human rights has constantly extended the application, the territorial application of treaties beyond the borders and till areas where the state have effective control and where the acts committed by their agents under their military or political influence. Consequently, we can see a consensus so that the obligation to protect or not to violate human rights go beyond the territorial limits of the territories of states. It also notes that the alleged violation of human rights occurred in the territory of the Arab Republic, which is a state party to the protocol, but beyond the national borders of the respondent state. So the court cannot declare itself competent because the alleged violations were committed in a state party to the protocol. To exercise its territorial competence, the court should make sure that the alleged violations were committed by a respondent state or by persons under its control. From this ruling, we can see that in order for the territorial competence to be established, we need two conditions, two preconditions. That the alleged violation be committed on the territory of a state party to a protocol, first condition, and if the violation of alleged violation have been committed by the respondent state or persons under its control. This is the second precondition. As we can see it, this ruling confirms the constant jurisprudence that its territorial competence is established as long as the alleged violation of human rights were committed on the territory of a state party to the protocol. But the court just added a condition, a practical condition, that the respondent state should be the one where the perpetration of such violation is blamed for that. And given what was said, the court is going to declare itself competent as far as Rwanda has committed and continued to commit violation of human rights on the territories of the DRC, which is a state party to the protocol. The third argument of the DRC is based on the fact that the jurisprudence of the Human and People's Rights Commission is in favor to the broaden the territorial competence of the court. There is no determining condition justifying the fact of not inspiring ourselves from the Commission of Human and People's Rights as suggested by Rwanda. And this was demonstrated in the introductive pleadings of my colleague Ivo Mikashi. Indeed, this court is not the only and sole mechanism of protection of human rights who have retained the status of state parties as criteria to determine its territorial jurisdiction. It was preceded in this by the Commission, especially its decision of May 2003 relating to the communication 227/999, which opposed the DRC to Burundi, Uganda, and to the respondent state. In this matter, as in this one, the alleged violation were not committed on the territories of the respondent state territory, but rather on the applicant state territory, which did not prevent the Commission from affirming its territorial competence and jurisdiction. So Rwanda tries to weaken the DRC because saying that the Commission did not really focus on this issue. But how can we imagine that the state party to the protocol can be kept responsible only if it is perpetrated on its territory and not on a territory of another state party? Honorable Vice President, honorable judges, it is the interpretation of Article 3 of the protocol that guides us to take into account the principle of usefulness of this provision. So any possible interpretation that will decline the territorial jurisdiction of the court because the violation of human rights were not committed on the territory of the respondent state would be a very negative precedent for human rights in Africa. This is for two reasons at least. On the one hand, this would mean that would take Rwanda as not responsible for the violation of human rights, and this would be new crimes without sanction. On the other hand, such a solution would mean that we encourage or we entice the respondent state and others to go beyond the national borders of their respective territories, to go and elsewhere and commit in full impunity violation of human rights on the land of neighboring countries, and not to feel responsible of their commitments to the Human Rights Charter. That is to say that Article 3 of the protocol would be empty from its object, scope, and meaning, that is to say the protection of human rights in Africa, and it will be null and void. In conclusion, Mr. Vice President, Honorable Vice President, Honorable Judges, the Court will reject and dismiss the submission of the respondent state and reaffirm its territorial jurisdiction in addition to the material jurisdiction to consider this. Thank you very much.
Applicant states you still have about 10 minutes to go. You still have about 10 minutes. Honorable Vice President, honorable judges, the Council of DRC believe they have brought sufficient submissions to the court following the submissions of Rwanda. The court is adjourned for 10 minutes, a 10 minutes break.